series called, okay, we'll start again, sorry. So hello, everybody. Welcome to our webinar series called Conversation on the Arms Industry. My name is Vanessa Canola. I'm a project assistant at Scrap Weapons, and I'm also an international security studies student at Charles University in Prague. Last year, I worked for the delegation of the European Union to the United Nations in Geneva in the disarmament section. And now I'm involved in several activities with Scrap in order to continue this journey in disarmament. And I will start by giving you a brief overview of Scrap's work before actually elaborating on the content of our webinar series and on this session in particular. So before understanding what Scrap does, it is necessary to understand what Scrap actually is. So Scrap Weapons means the strategic concept for the removal of arms and proliferation. And it is a project whose aim is to reframe the debate around general and complete disarmament. And it is housed at the Center of International Studies and Diplomacy at SOAS University of London. Our main goal is achieving the legal obligation of all nations to negotiate general and complete disarmament. And actually, this idea is not new. It was included in some suggestions proposed by the NAM, the Non-Aligned Movement. It was present in some US Soviet proposals, and it was also part of the President Kennedy's plan for general and complete disarmament. At present, Scrap Weapons is building a global constituency to request that UN Secretariat reactivates the General Assembly's mechanism of special sessions devoted to disarmament. And in particular, we are pushing for the activation of the 4th special session on disarmament at the United Nations General Assembly, and its inclusion, of course, in the new agenda for peace. So we call on all states, including our governments and their representatives, to support this initiative by writing to the UN Secretariat their views, proposals, priorities, recommendations for the new agenda for peace. And you can do it using the email that we will post in the chat. And of course, you can also learn more about our mission, our initiatives on our website, also posted in the chat. And we will also link the information pack in order to learn more about what we are doing. So you can find all the necessary information there. And as I mentioned before, our webinar series is entitled Conversation on the Arms Industry. And its goal is to create a space for open-ended discussions, which help provide an insight into the arms industrial complex. And this is done by engaging a variety of different actors, which help fostering the discussions. For example, we had also actors part of making, selling, monitoring, and controlling weapons, but also those working with communities directly or indirectly affected by the arms industry, involving academia, researchers, think tanks, and members of international organizations and NGO. So we are really trying to provide our audience with an holistic approach concerning the arms trade, which we think is really important to have a general overview and to dig more into the topic. So today, we will focus on the social responsibilities and on the ground realities, which is also the title of our webinar session. And more specifically, we will touch upon the following topics: the position of arms export controls and international law, human rights and arms trade, and Human Rights Council mechanism to fill the gap of understanding when it comes to arms-related issues and risks and human rights. Then we will focus on North and Sub-Saharan Africa, addressing the legacy of weapon transfer in the region. And we will also talk about the Yemen case study and its on-the-ground reality. So to sum up, this webinar, as I said before, wants to build bridges between theory and practice, human rights and disarmament, and international fora and on-the-ground realities. But before jumping into the conversation, I would like to do a little bit of housekeeping. So the webinar is being recorded and will be published on our website and on our YouTube channel in the next couple of days. So feel free to share the recording and to comment on it. And once the speakers have given their presentations, we will open up the floor for a little Q&A. So feel free to write your questions in the chat, and we will try to answer them during our conversation. So yeah, after this brief introduction, it's time to introduce our speakers finally. So we will have first Mark Bromley from SIPRI, Florence Foster from the Quaker UN office in Geneva, Nourhan Moustafa from MAAT for Peace, and finally, Martin Butcher from OXFAM. So, okay. So I would like to give the floor to our first speaker, Mark Bromley, connected from Australia. So it's very nice that we have you here. Your presence is precious, and we are glad very glad that you will be speaking on the arms trade. So over to you, Mark. You can start by sharing your screen, and you can also start with your presentation. So thank you very much again.
Hello. Yes, I should share my screen, should I?
Yes.
Yes.
That would be perfect.
I don't have any slides though. Do I still need to?
Okay. So if you don't have slides,
No. Yeah.
Yes, no worries.
you would just see a couple of Word documents, and if
no worries, no worries.
No, sorry, I don't have any slides. Sorry. Yes, thank you so much for that kind introduction. Yes, I'm joining you all the way from Australia, where I'm currently based until the middle of next year. But I'm still very much working at SIPRI, which I'm sure most of you know. Yes, a Sweden-based institute that does work on peace, conflict, and disarmament and armament issues.
Yes.
I work in SIPRI's dual use and arms trade control program, doing work on different issues to do with the regulation of both the conventional arms trade and the trade in dual use items. So I was kind of asked today to give a few introductory remarks about the position of the international arms trade and international law. So I wanted to try and kind of cover 3 points in this brief presentation. So firstly, talk a little bit about the position of arms export controls in international law, say a little bit about the different multilateral and international legal and political instruments that exist in this space, and then say a little bit about the different ways in which they're applied at the national level. So all issues that we talk about in the field of peace and security are unique and different, but I think it's fair to say that the arms trade is of a certain type, is very kind of particular in certain respects. And I think one way of kind of thinking about the particular position that the arms trade has, particularly with regards to international law, is to think about it in terms of having two kind of overarching legal principles or norms that kind of govern the way that it operates, and which to a certain extent kind of pull in opposite directions at the same time. So the first of these kind of legal principles, I think, is the idea that states have a very clear obligation to have a system of arms export controls in place and to restrict or prohibit transfers in certain specific cases. So you can see that in Article 2 of the UN Charter, which states that all members shall refrain from giving assistance to any state against which the United Nations is taking preventative or enforcement action. And you can also see in Article 1, common to the Geneva Conventions, which says that states must respect and ensure respect for IHL in all circumstances. So I think in those two documents, which are at the very kind of heart of international law, you can see the principle that states, on the first hand, shall not supply arms to states that are subject to a UN arms embargo. And in the second case, the principle that states shall not supply them to states that were going to use them in violation of IHL. And obviously, if you're going to be able to do that as a state, you need to have a functioning system of arms export controls in place. So there, in these two very kind of fundamental documents of international law, clear principle, states have to have a system of arms export controls in place and prevent certain transfers. So against that, you have this second kind of legal principle, which is also very kind of well-grounded, which is that states have sovereign control over decision-making on arms exports. And you can see that, interestingly, you can see that again in the UN Charter, but in Article 51, in this case, which says that nothing in the present charter shall impair the inherent right of individual or collective self-defense. You can also see it in a range of other instruments. It's there in the General Agreement on Tariffs and Trade, and also in the EU's Treaty of the Functioning of the European Union, which specifically excludes issues to do with the production or trade in arms, munitions, or war material from the cover of EU regulations. So in these other kind of international legal instruments, you have this other principle which says that states are free to choose how they structure and implement their systems of arms export controls, and that this is something that's under their kind of exclusive kind of sovereign purview. So if you take those two kind of principles, those are the kind of two principles which have kind of governed kind of state action in the field of arms trade controls over the previous decades. Out of that, what's emerged is a situation in which, on the one hand, you have an increasingly broad and also detailed set of standards concerning the elements that a functioning arms export control system should have. So they're laid out, for example, in the Wassenaar Arrangement, which was established in 1996, the EU Common Position on Arms Exports from 1998, and then revised in 2008. And of course, in the Arms Trade Treaty, which was adopted in 2013. So these documents lay out in quite specific detail what are, the elements of a functional export control system in terms of the activities that need to be controlled. So all three documents state clearly that in addition to exports of military equipment, states also have an obligation to control transit and transshipment, and also the brokering of arms. And then secondly, the items. So what kind of constitutes military items? What are the items you need to control through your export control system? Very well specified, particularly in the Wassenaar Arrangement, whose military list is very widely adopted, even by states that aren't part of that agreement. And then lastly, and importantly from today's conversation, the criteria. So the standards that should be applied when assessing arms exports. And here, the broad brushstrokes of these criteria are kind of common to all three of those documents, in the sense that states have to have consideration of the risk that the weapons will be used in violations of human rights, in IHL, used aggressively against a neighboring state. So again, we have quite detailed criteria that have been elaborated in these various multilateral instruments. So that's this kind of like very kind of broad and detailed set of international multilateral instruments. But then on the other hand, you continue to see the kind of assertion, the recognition of this other norm of sovereign right. And so you continue to see differences in the way in which those obligations are then applied at the national level. And it's interesting that you see this even within the European Union, which has gone through definitely the most kind of broad and far-reaching process of harmonization in the field of arms export controls. But even here, you see member states showing clear differences in the specific content of their export controls. And these differences, you can think of three areas. So like firstly, which ministries and agencies are tasked with assessing export license applications and the ways those decisions are made. So secondly, states' foreign and security policy interests, their historical ties with particular recipient states. And then thirdly, the size and the composition of the defense industry they have and the extent to which they view exports as a means of generating revenue for that industry. So in all three of those areas, none of those issues are really kind of smoothed out by these EU instruments, and states continue to differ in all of those areas, even within the EU, in terms of how those factors play out, which then makes, leads to differences in terms of whether or not they're more or less likely to authorize certain exports. And you see that clearly with, again, something else I think we're going to be talking about later today, the decision-making that states have made about exports of arms to members of the Saudi-led coalition that was been operating or engaged in the armed conflict in Yemen. So there you saw, on the one hand, Germany, Sweden being quite restrictive, France, UK, when it was still an EU member state, and even afterwards being much less restrictive, even though they're all part of the same kind of common legal framework created at the EU level. So I think I'll conclude with just thinking about three kind of ways in which, there's a lot kind of going on in this space at the moment, but if you think about this kind of interplay between these different legal principles, the kind of the international kind of set of the creation of an obligation for states to have controls, and secondly, this assertion of the sovereign right to interpret those controls in different ways. I think there's three kind of very kind of fast developing, rapidly evolving ways in which that tension is kind of playing out in recent years. And so firstly, you can see it, I think, in the series of court cases that we've had in Italy, in the UK and France and elsewhere, where there's been efforts to challenge the legality of states' export licensing decisions, and particularly to challenge the extent to which decisions to supply arms to the Saudi-led coalition reach the criteria that have been, as explained, that have been agreed at the multilateral international level and then applied through national laws and regulations. So there you see this interplay between the international law and the national level. I think secondly, I think you can see it, and again, looking at the European Union, various attempts to elevate decision-making processes to the supranational level to achieve greater standardization in the outcomes of states' decision-making on what to export. We've had a variety of proposals and discussions within the EU, some of which are focused on facilitating exports and others which are focused on restricting exports that would give different EU institutions a more direct say in specific arms export decisions. And then thirdly, I think there's been, and again, something I think we're going to be hearing more about, I think probably in Flo's presentation, efforts to kind of assert that the arms manufacturers are not only bound by the obligations created by states' national export control systems, that isn't the sum total of what their obligations are in terms of international law, but they also have responsibilities under other legal instruments, such as the UN Guiding Principles for Business and Human Rights and the OECD Guidelines for Multinational Enterprises. So obligations to conduct their own assessments of the human rights or IHL risks associated with their exports. So again, a kind of questioning and negotiation between this national level and the international level. But I think I've talked for long enough. Thank you very much for having me take part in this. I'm looking forward to the discussion and hearing the other presentations. Thanks so much.
Thank you very much, Mark, for your presentation. And thank you for highlighting the key documents at the heart of international law, which are essential in understanding the issues from a legal point of view, and also for highlighting the interplay between the international and the national level. So this is a very essential point. And we are glad to have you here, and thank you very much for your intervention once again. And we all know that this is just a taste of your research and expertise, which covers a variety of topics, such as the transparency of international arms transfer, the financial value of arms trade, arms export policies of EU member states, EU engagement, as you mentioned, and arms export policies, combating the illicit trade in small arms and light weapons, and arms trade treaty. So your research is covering a lot of different topics, but you were able to provide us a very nice overview and really explain in a simple way, which is essential in order to attract also students and very different actors into this world of arms trade. So thank you very much once again. And I'm glad now to introduce our next speaker, Florence from the Quaker UN office in Geneva. And you have, Florence, a very diverse professional background, and I think it's going to be reflected in your presentation. You have experience in human rights, mediation, and also arms control. You are now working, as I mentioned before, for the Quaker UN office in Geneva. And you are providing us with a more holistic and social justice approach. And I'm sure we will see it in your presentation. So without wasting time, you can start. You can share your screen if you have slides. No. If not, you can just present your topic. So thank you very much once again. Over to you.
Thank you, and thank you very much for having me. And Mark, you stole a couple of my points, so I'll try and sort of expedite over them. But perhaps let me start with a few words about the organization. So as was mentioned, we're a pacifist social justice organization that works at bringing people from the UN, multilateral organizations, governmental delegations, NGOs, and the like, together in informal and off-the-record conversations to achieve changes in international policy and standards and practices. And so really at the multilateral level, policy level. We call that quiet diplomacy. So it's a big bag of a lot of different things that we do. In the program that I lead, we've had to navigate creatively the realities of the UN, multilateralism, and geopolitics. So when I say that we're a pacifist social justice organization, we're also limited by the realities of what we're offered. First and foremost, what we do is to prevent the worst harm by addressing and curbing the impacts of weapons on human rights beyond the right to life, and engaging with a wide range of actors, including the economic drivers of these exports of weapons, namely the businesses behind the bullets. So as was mentioned by Vanessa, I'll be talking about the sort of human rights aspects of the work that we do, looking at what human rights frameworks have been able to do, and also touch upon business and human rights as well. So what with the implementation of many arms control and disarmament frameworks, agreements, and treaties being undermined by politicization and commercial interests, as well as the lack of human rights dimension in arms control's decision-making, some actors, including ourselves, have looked elsewhere, seeking to leverage the UN human rights bodies to explore their role in highlighting the violations from arms transfers and in reminding governments of their human rights obligations in relations to them, in view of curbing those violations, obviously. We have found that leveraging the UN human rights mechanisms to advocate for stricter arms control both reflects the harsh realities that arms transfers and their acquisitions by civilians can negatively have on human rights, but also complements and offers prospects for re-energizing disarmament and arms control frameworks themselves. There are several examples of how the human rights community has done this today. For instance, there are joint Human Rights Council resolutions by Ecuador and Peru for the last 10 years, actually, on looking at the impacts of arms transfers on human rights, but also on looking at the impacts of acquisitions by civilians on human rights as well. While many of us in this room, and I would hope that's the case, feel that a human rights body should be addressing the impacts of weapons on the lived experiences of those people affected by them, that doesn't come naturally to some of these bodies, where there's continual political pushback on having arms control discussions at the Human Rights Council. So having these resolutions in the first place was and remains significant, and protecting them today is critical to our work, but also to providing the human rights community with space to be able to address human rights risks relating to arms control and to the so writ large, right? Arms control, looking at arms transfers, but also looking at acquisitions by civilians. I'll give you a couple of examples of how some of our colleagues have been leveraging these spaces that have opened up. So the Women's International League for Peace and Freedom, for instance, has been using the Universal Periodic Review of countries as well as human rights treaty bodies of exporting states, but also of importing states to address some of these harms. They, for instance, submitted concerns to the Committee on Economic, Social and Cultural Rights of Germany, UK and Cameroon, and also advocated for the inclusions of arms control measures in the Universal Periodic Review of Germany, Colombia and the Democratic Republic of Congo. I'll give you a small example of impact because I think that's also important when we talk about policy. An example has been also for this Swiss review in 2016 by the Committee on the Elimination of Discrimination Against Women and Girls. So I think one of the important things is that some of these recommendations came directly from NGO inputs, like the Women's International League for Peace and Freedoms. So in that review, the Committee on the Elimination of Discrimination of Women recommended for Switzerland to conduct an independent study to analyze the links between the uncontrolled possession of arms by men in the state, so Switzerland in this case, and the impact on gender-based violence against women and girls. This led directly to 2 parliamentarians from different parties to submit 2 motions to further work on these issues. So again, direct impact. But moving beyond state responsibility through these human rights mechanisms, it's also important to look at the governance gap regarding human rights responsibilities of the arms sector, so the private sector in this case, writ large. So not just the manufacturers, but also the financiers, those ensuring these transfers, etc., which have been recognized in global standards that Mark actually also mentioned. So the UN Guiding Principles on Business and Human Rights, and the OECD guidelines on multinational enterprises, and that since 2011, alongside increasing amounts of hard law being developed in numerous countries. And actually, Mark mentioned a few countries where that hard law is being used to be able to bring cases to court, sorry. So what we've seen is that the arms industry has actually been very slow to acknowledge their own human rights responsibilities and argues that this is discharged by their compliance to state licensing systems that Mark mentioned. While we do not refute the state's responsibility as a licensor of arms transfers, we would also argue that the arms sector plays a pivotal role in the manufacture and export of these weapons and therefore on their human rights impacts. As a step in the right direction, we would invite them to apply these principles, so the UN Guiding Principles on business and human rights, through human rights due diligence processes and policies that go beyond what they're currently doing to have a preventative impact. So aim at preventing human rights harm as opposed to currently what is being done, which is a purely defensive corporate due diligence process aimed at protecting the company and its bottom line itself. Failure to truly address human rights risk caused by their business models could entail not only reputational risk, but important legal risks and complicity in serious international humanitarian law violations. And again, Mark hinted to a couple of those. Perhaps an example to illustrate what we're meaning by this is the case of Yemen. And I know we'll be talking about Yemen in a few minutes, but the use of Raytheon, so US manufactured bomb in the Saudi and Emirati-led airstrike in 2019 on residential homes in Yemen, which killed 6 civilians, including 3 children, amounts to serious violations of international humanitarian law. Now, the question is, who is responsible? Is it the Saudi and Emirati states? Is it Raytheon? Is it the US government? Well, in the application of the UN Guiding Principles, all share a responsibility in the harm done. And the licensing process of the US cannot absolve Raytheon from having to take its responsibility to respect human rights seriously. In real terms, what this means in our work is that we supported the UN Working Group on Business and Human Rights in developing an information note on the arms industry to raise awareness of the points that I've mentioned above, and engaging with the member states in Geneva here who are currently discussing the role of industry in responsible international transfers of conventional arms in the context of the Arms Trade Treaty CSP9 cycle this year. While some have taken the bureaucratic approach of resolving the issue of how to engage with the industry by having roundtables at the capital level to raise awareness of the ATT, or even trying to get additional private sector actors to come to the ATT meetings themselves, we believe that a necessary complementary conversation around the normative basis of that conversation is critical. So relating to their responsibilities, not only to how they can engage with the ATT as a sort of bureaucratic treaty process. So I'll close there, but I think with major questions over the responsibilities and the potential legal liabilities of major armed companies and states making it into the limelight in recent past, and an increasing empowerment not only of the legal systems, but also of the general public requesting accountability, the conversation needs to continue on multiple fronts, at the Human Rights Council through national mechanisms, but also at the Arms Trade Treaty, where an increasing conversation about human rights and the impacts of the arms transfer is critical. I'll leave it at that and hope that it wasn't too technical in nature, that I was able to give a couple of examples that give a bit more color, but also happy to pull a few of the strings that I've put out there in the Q&A. Thanks, Vanessa.
Thank you very much, Florence, for your insightful presentation. And I truly appreciated the bond between human rights and arms trade in explaining the impacts of arm transfers, especially on civilians and children. And you mentioned that these are also violating IHL, so it's a fundamental problem to be tackled. And you also mentioned that the participation of several actors is actually essential in the Arms Trade Treaty and beyond. So the industry has to engage there, but also show their engagement in other ways, in a very practical and efficient way, in order to do something to tackle the issue. So this is necessary, and we have to work more on this with them as well, being on board. And now, without further delay, I pass the floor to Nourhan Moustafa from MAAT for Peace. And she's an expert in international humanitarian law, human rights as well, arms proliferation and protection of civilians. She's the head of the IHL unit at the MAAT for Peace, as I mentioned before, and she has been at the forefront of promoting and protecting the rights of vulnerable populations affected by armed conflicts. She led an initiative, very important initiative on social media to raise awareness of IHL and disarmament among law students, which has successfully supported up to 9,000 young men and women from all over the world. So thank you very much for your work. And now you can share your screen. I'm sure you have a presentation because I saw it. So you can start with your speech. Thanks again for being here.
You see?
Yes, here it is.
Thank you so much for the invitation, and I appreciate all the work you did for this project, especially because that I feel that's time to have the collective cooperation together as academic, as an expert, as the civil society, government, and international organization. I'm also glad because that today we have a movement in our disarmament community, and try to raising the idea of the unlegacy transfer weapon, the area of armed conflict. Especially yesterday, also I'm glad to starting this with my organization to organize like the round table with the government about the unlegacy transfer weapon in area of armed conflicts through the PMCs. And as you know, the PMCs also is the hardest situation. I'm also glad today that I will share some insight about the new region or different region, because I know that some of experts will sharing some insight about the MENA region, especially in Yemen, but I will take you in Sub-Saharan and North Africa, because also this is part of the region affected by the unlegacy transfer weapon in this especially region. And if we talk about the realistic from the addressing of the idea of weapons on the ground, we will think about also about the future. If we're starting to talk today about that, we need to cover all the gap or all the risk or challenges about the legacy transfer weapon. We should also think about the future and what we should to work together to achieve our goal, to achieve the goal of the one global system, international security system. I know this is like a butterfly, but we tried together to think as different actors, we should to think about this. Because that in my presentation, I will cover like overview about conflict in Africa today, but I know many people know about that, but I was stressed about some country in the region to like that give to us like the reason what happened today and what happened and what we should to do in the future. And also I will give some try to ways about the idea of illegal armed transfer, and I will try to challenge myself and you with some argument why we don't think about the regional and international organization can play a role. And then I will give thoughts about the role, about the role and the effort of the civil society and the future need. When we talk about the conflict today in African, we will mention about the extent and the complexity of the conflict on North and Sub-Saharan Africa. And that gives to us to think about the scourge of the armed conflict in Sub-Saharan Africa region in 2022 and 2020, early in 2023. We found 5 of 10 least peaceful countries globally were in the region, like the Central African Republic, the Democratic Republic of Congo, Somalia, South Sudan, and Sudan. In addition, Burkina Faso, Mali, Niger, Nigeria, Somalia ranked among the top 10 countries worldwide most impacted by tourism. During 2022 and 2023, we awarenessing trend of political instability and authoritarianism was apparent of the content. And also, a number of the CAPs were staged in 2020 to 2023, including successful military CAPs in the Burkina Faso, Guinea, Mali twice, and Sudan, and Field 1 in CRA, and Madagascar and Niger. So that's not only in the region. We found also violation, and maybe in this slide, you will find with me the further escalate across the Western Saheli, and where radical Islamic group, both domestic and transnational, expanded their operation and reached to the country. And we found in the East Africa, you found Ethiopia registered an easy ceasefire between the center government and the Tigray people, and the truth that the highlight instability, giving the multiple region and defined entity, the identity-based the conflict taking place elsewhere in the country. So, in the north, we found Libya, civil war, starting from 2014, involving different actors there, external intervention, and this is also the one of the country sending a legacy transfer weapon to Libya. It's one big problem because the hot area in the conflict region in Africa. Western Sahara, that long-standing dispute between Morocco and Brussels, as we know, and that the finding the sovereignty of the Western Sahara. And so, if we think about the illegal arms trade, that we will find that big challenge in North and Sub-Saharan African, because the corruption, because that we don't have a system, because that we don't trust about the common the building common trust between this country and the region, and we have a violation, and we don't find any strategy for developing the system in this region. And that's get easy for the suppliers for the arms to send by different ways to those arms in the region. And we also found the more specific, when we researched about the situation in MAAT, that we found also the the big thing from of the type of the weapon, the small arm and light weapon, because this is like easy availability, low cost, and they can transfer very easy. And also, we during our research in 2021, and we found also not only about the small and light weapon, we found also heavy weapons like machine guns, and that also military equipment that also sharing in this area. So that main, as I mentioned before in the first slide, that we have the suppliers, armed suppliers. They a big networking in this area, and they especially because the area of armed conflict, they don't have a system to check any weapons, to check the rules. And for example, not only about the sub-Saharan, also MENA region, Yemen, for example, when they try to, they found some of the weapons sent by Arab Sea to Houthi group, and they used Iranian language because that we don't have a system to check the language, to check the like that, put in the system to check that this illegal or legal. And one of the important comment yesterday, for example, when we talk about the PMCs and that the way from the transfer weapon, they mentioned that as a government, how to find this legal or this not legal. And this has surprised me because that means we don't have a system, we don't have a framework from this type of the unlegacy, in border, I mean. Sorry, in border. And that also helped from the external supplier to find a good marketing from for sale different type of weapons and sharing easy. I would like to highlight from this is a slide that example about the countries. Who's the big country for the selling and the transfer illegally weapon to the sub-Saharan Africa? That we found Russia is the most favorite from this area, China, United States, and also Europe country. They play a big role from selling this selling and find marketing from a legacy transfer weapon in area of armed conflict in sub-Saharan Africa. So that gives me thinking as a work in this field that, okay, now how can we resolve these risks? How we can work on these challenges? Are we need to new agreement? No, we have a ATT, we have a different meeting now in UN just to play the role, but the regional organization attend also, but they not active, because that I'm trying to thinking, are we need to rebuilding the regional organization to resolve this this issue, or they can cooperation with a different NGO, for example, or international organization. I found some of answer from my question when I start researching about this idea. I found that the big challenges from this regional organization, and especially in African region, they try to make an initiative, but for African region have the idea of colonization, colonialism, and maybe they don't they don't take action, and some of the country of this region, they not take action, and maybe this is problem. And another way I feel the fundraising, because for example many initiative now is try to play role, but if you see the fundraising, you found that some country in Europe that provide the money to support this initiative, but maybe if the Europe country, for example, stop this funding raising, they will not continue. And that's one of the main issue now for the regional organization, the situation of funding. and the building trust in the same region, not only the resources, the building trust and that thinking as a one country to put the one strategy or the international security strategy, regional security strategy can help them. But today we don't find like this cooperation between this country or building the trust. And maybe that's time also to think about to support the regional organization to play the role to, for example, make a national strategy, support for advice, share knowledge, training, building the trust also between those countries. And but I think it's time also to think that how we can cooperation or how can advocacy for support the regional organization to play their role. And I will talk about also the final point about the NGO. I'm so glad because I'm working the NGO and I feel that civil society have a good role to be like the peace part in any negotiation, because they share their knowledge and their experience with the country in different meetings. For example, ETT, MAAT usually try to share the consultation advice for in the meetings through the oral intervention, try to engage with different government inside the room to support some idea, to highlight some important point, and that tried through the media also to support the knowledge and the small introduction or the baby step for introduction to people to understand why the meaning of what I mean about the armed trade treaty, or we try also influence some country in the region to be part from different disarmament agreement. Especially we will talk now about the small and light weapon or the ETT issue. We try also to play our role to promoting this convention, and we try to be play a role as a observing and reporting issue. Like we usually try to attend and listening and collect the type of the intervention by different country, try to make an analytic report to sharing in our website about different type of meeting, and especially small and light weapon. We have a report, different report. We publish some report about the small and light weapon in Arabic language also to help many people to understand the situation of the small and light weapon, for example. And we try to play as a policy advisor also. We try to think about that, what we need from our work and also from the government, what our expected from the regional aspect, or also the governance aspect from this type of work. And as I mentioned when I start my presentation, that MAAT glad because successful yesterday to organize the important meeting with the different government and also international organization to talk together about the situation of PMCs and the armed trade treaty and what we need for the future, and why we should do the armed trade treaty to cooperation with PMCs group in the UN to understand that the framework of the PMCs. And that future need, I think that we need to highlight, to focus more about the regional organization. We need to open also, and we try also to advocacy for sharing to ATT to highlight a different topic in their agenda, like the new technology, PMC's issue, children worker, because the children worker can also play a role from the transfer legacy transfer weapon, and can be used by different actors in the area of armed conflict. And I feel that that today that's the starting point. I would like to all of us to continue that discussion, and we try together to find the solution for this problem. Thank you.
Thank you very much, Nourhan, for your presentation, for highlighting both some key facts, historical facts, and the implications of the legacy of the arms trade and illicit transfer in the region, which should not be overlooked. And you also mentioned the importance of regional organizations and NGOs. They should be included in the debates, both in the international fora, but also in other types of meetings and so on. So every voice is essential, and every player can play a crucial part in tackling the issue. So thanks a lot for your presentation again. And now we have finally the last speaker, last but not least. So now is the turn of Martin Butcher from OXFAM. He's a policy advisor on conflict, international humanitarian law, and arms for OXFAM. He leads the work on global arms control issues. He worked on the 2014 arms trade treaty negotiations and researches the impacts of arms flows on civilians in conflicts across the world and also in Yemen. So he will elaborate more on his research, and now we are ready to learn more, let's say, on this region that faces several challenges, but I'm sure that you are the appropriate person to explain this to us, because you know more, of course. So please, it's your turn, and thanks a lot for your participation. It's really precious. So over to you, Martin.
Thank you, Vanessa, and thanks to the other speakers for what's been a very interesting session so far. I'm going to, I think, focus down on the themes that others have covered, specifically in the UK. That's although I work globally for OXFAM, I am in the UK, and that's where a lot of the work is focused, and how that impacts UK arms exports on Yemen. I'm going to try and make my presentation brief because a lot of these themes have been really well covered. So here we go. There we go. So yeah, so what I'm going to look at for a few minutes is the gap between the rhetoric on UK arms export legislation and the reality of UK arms trading, because the gap is huge. And I think this is a good illustration of principles that others have mentioned already. So the UK is a big arms trader. The recently released figures, the SIPRI have pulled out for countries around the world. The UK sold or at least issued licenses for £8.5 billion worth of sales last year. The actual figure is going to be much higher than that. The UK has an open licensing system which allows essentially unlimited amounts of arms equipment services to be sold to destinations where an open license has been granted. The relationship with Saudi Arabia is a good example of that, and I'll come on to that a bit later. But the really appalling thing, I think, actually in the context of what we're talking about here today, is over 50% of that figure went to repressive regimes. And this is a theme in UK sales over a long period. We've had you know, published public figures by the government in online reporting going back to 2008. You see this this figure here from 2011 to 20. We sell a lot of weapons to countries that the Foreign Office itself puts on its list of human rights concern, and even more to countries that organizations like Freedom House say are not free or only partially free. And within that, you know, Turkey is a big example. Libya, before the overthrow of the Gaddafi regime, was an example for a few years. Egypt has been an example. The UK has a very bad record of selling large amounts of arms to countries where human rights are abused and where democracy is more or less repressed. So this is what the UK government says, that it takes its defence export responsibilities seriously, and that in particular, that one line, the UK has one of the most robust arms export control regimes in the world. As it happens, this is an answer from Parliament that was given in response to a question about the arms sales relationship with Israel. But they use exactly the same language every time a question about human rights and arms exports is posed to the government in Parliament, whatever the destination. This is the answer. And at least in theory, on paper, it would be hard to disagree. The UK over many years has built up an arms export control system that on paper looks quite restrictive, and if it was operated robustly, as they say, it probably would be quite restrictive. But as I'll say, as we'll see shortly, this is not what happens. The system is not robust at any point in the way it's operated. Oops, did I jumped one? Okay. So the UK is under a number of obligations regarding arms export legislation. I've pulled out a few here. Obviously, we used to be part of the EU common position, the EU system, and that system is based on, in large part, on work that the UK did for more than 20 years in developing arms export controls across the EU, and still reflects a lot of UK legislation. But we're now out of that. The Arms Trade Treaty is a core piece of international law, with its prohibitions on export where there's knowledge that certain kinds of crimes, human rights abuses, breaches of IHL are going to be committed, and it's Article 7 obligation where there isn't such knowledge to assess risk, and this is incorporated into UK law and operated through the strategic export licensing criteria. The UK government does not do this well. It just doesn't. We have, in particular, so zeroing in on the example of exports to Saudi Arabia for use in Yemen, we have now 8 years of data in the ways that UK aircraft, UK bombs and missiles, other equipment have been misused, have been used to destroy civilian infrastructure, have been used to kill civilians, and yet the UK is once again in court fighting campaign against arms trade and OXFAM, and Watana as an expert witness with OXFAM, claiming that arms exports to Saudi Arabia for use in Yemen are still legitimate. The criteria, which, you know, if enforced properly, we say would not allow such exports either to Saudi Arabia or to many other places. And I think Common Article 1 of the Geneva Conventions is extremely important in this case to OXFAM, because that requires states not only to uphold international humanitarian law, but to do all they can to ensure that other states do the same. So arming a country which you are well aware is bombing civilians with arms that you've supplied cannot be fit with that. The problem really is that the government increasingly over years has come to interpret its responsibilities under national law, under the ATT, under wider international law in the minimum way it can. It looks for ways to evade its responsibilities. It looks for ways to minimize its responsibilities rather than looking at the intent, the purposes and objectives of a treaty and saying, okay, what can we do to uphold that? And we have seen that get worse pretty much from the moment that the Arms Trade Treaty entered into force. And you know, we'd had several years, more than a decade really, of fairly good rhetoric, if not great practice from the British government. But you know, in 2014, the government took a rightward shift, a pro-export shift, a pro-business shift, as they would see it. And we started hearing things like when British tear gas was being used on students and other protesters in Hong Kong, the Foreign Secretary coming out and saying, well, if we didn't sell it to them, someone else would. It doesn't matter. And then the civil servant correcting that later, saying, well, what the ministers meant to say was, we regard human rights as obligations as extremely important, but they don't. I think Florence had touched on the UN guiding principles, but you know, business has a responsibility to follow national law, to comply with national law. We have seen, unfortunately, multiple examples, even in a weak compliance regime. We've seen multiple examples of companies just not doing that and ending up being fined in the past decade or so, and where we bridge over into corporate social responsibility concepts that again were mentioned earlier. British industry is just not there, and they're not there in their intent to follow really the intent of law either. They are quite happy to say, well, the government is responsible for setting out the arms export control regime and for operating that regime. We just follow that. as if they have no social responsibility to look at where their arms are being used, how they're being used, what's being done with them. It's a moral black hole in a way, which just reinforces the problems with the government's attitude to the export of arms. I'm critical also of unions in the UK. The Unite, which by an irony organises workers at OXFAM, also organises workers at BAE Systems and other arms workers around the country, together with other unions, but Unite is the biggest one. They are absolutely ferocious in their defence of all and any arms sales, and encouraging the government to promote arms sales. And while the unions obviously have a responsibility to their membership to protect their jobs, they also have a role in expressing solidarity with workers and with people in other countries. We've quite often seen British unions do things like work together, with unions in Iraq to try and protect the rights of workers in Iraq. The same, the defense of Ukraine has been something where international solidarity has been shown. Internationally, we've seen unions working to restrict the worst elements of the arms trade, going back to 15 years or more ago now in South Africa, when dock workers refused to unload Chinese arms that were being sent to Zimbabwe at the time of the greatest repression towards the end of the Mugabe era. That was a great example of a union showing solidarity with others internationally. In more recent years, we had the example of workers in France and Italy refusing to load arms onto the Bahri Yambu, a Saudi ship taking arms to Saudi Arabia, most likely for use in Yemen. So unions can play a positive role, but in the UK they don't. So that again compounds the problems in the system. Parliament in the UK has a role in this system. It has a duty to scrutinise policy and practice of government. And in the UK House of Commons, we have the Committees on Arms Export Controls, which is a joint committee of 4 committees, which comes together specifically to scrutinise UK arms exports policy and practice. But for the last 8 years, it's really done its job very poorly indeed. The High Court in the first CAT court case about Saudi Arabia said that the cake had a pivotal role in the system, that it was very important. And in the Parliament between 2010 and 2015, we saw then Chair Sir John Stanley taking a very strong role in challenging the government on arms exports to countries of human rights concern, compiling long reports, pressuring the government in Parliament and trying to effect change. But since the 2015 election, that has really stopped. The committee's last report about annual report on the arms trade only covers 2019. They haven't had a meeting this year at all. They haven't had evidence hearings since 2021. The system is broken. So what we end up with is backbenchers who have little power within the way Westminster works, left to call debates on Yemen, on human rights situations in other countries, and to try to pose questions to the government and to challenge government activities. But they are, in our system, largely powerless, particularly when, taking you back to the slide, about the government's policy position, all you get is repeated insistences that we have a robust system and that's it. So looking across that broad spectrum, the people who are supposed to run a robust arms export control system, who are supposed to look out for the protection of the rights of civilians in conflict, are not doing so in the UK, or are doing so very poorly indeed, largely for commercial reasons. So what does this mean? What does it mean in particular for the people of Yemen? Because that's the report that OXFAM published that I wrote back in January that got a lot of attention. So it means that we think there have been 23 billion pounds worth of arms sales to the UK from the UK while the Saudi-led intervention in Yemen has been going on. 7 billion in published licenses and 15 billion under open licenses, the unrestricted, unrecorded system. And that open license, those open licenses are incredibly important because it's under those that things like the maintenance of fighter jets is done, and a lot of the supply of spare parts for aircraft and for weapon systems, communication systems, targeting systems, that's done under there, and we just don't know the full extent of that. So, but the preference for trade over human rights in the UK in those 8 years has been just terrible, and this has resulted in Yemen in massive civilian harm. So the report that I published, as you see, it showed 1,700 attacks on civilians in 14 months. That's roughly 4 a day. And the devastation that has caused in the country, not all with British weapons, it must be said, but the UK has been key to the war effort by Saudi Arabia, has been absolutely shocking. You know, the population, over 80% of the population requires humanitarian assistance now. There are probably about 7 million people who are close to famine. Water systems, energy supply systems, the medical system, telecoms, all have been broken down, and we've seen periods where there has been you know, concerted, deliberate attacks, for example, on telecommunication systems in areas under Houthi control that have made coordination of humanitarian assistance much harder. We've seen the deliberate destruction of roads, bridges, other transport infrastructure, again, compounding humanitarian difficulties. The OXFAM itself has been attacked on a number of occasions right back at the beginning of the Saudi intervention. A warehouse of water water equipment supplies was destroyed in Sana'a in what was a deliberately targeted bombing. Not long after, a solar powered water pumping system for some villages on the Yemen-Saudi border was destroyed, and Oxfam was told that it was a terrorist encampment and facility. A water facility that we put in for a Médecins Sans Frontières hospital was bombed at Abs. So the kinds of destruction are incredibly widespread, have led to thousands of civilian casualties directly from the attacks, and hundreds of thousands of indirect casualties. And within that, there are identifiable war crimes committed by all parties to the conflict, including Saudi Arabia. And yet, because of a broken system at home, UK arms supplies continue. So briefly, what needs to change? Well, the objects and purposes of the Arms Trade Treaty, which really put human rights and the prevention of human suffering above profit, have to be taken seriously. The way UK law is implemented has to become much more robust, in line with the spirit of both national law and international law, respect for IHL, respect for international human rights law, has to become much more serious. And for business, corporate social responsibility, needs to be taken seriously as well. So that's a narrow focus on the UK after the broader picture from the rest of the seminar. Thank you.
Thank you very much, Martin. It was really, really interesting. And I'm extremely glad that you touched upon the UK's involvement in the arms exports and the role of unions as well. And other players. You mentioned parliaments, the parliament, the governments, etc. So there is a lot of room for improvement, not also during the discussions in the ATT, but also within the national institutions. So we are a bit over time, and I would wrap up and ask you one general question. We can follow the order of the speakers in order to conclude our session. So based on your research, expertise, work, etc., which recommendation would you pick in order to curb this phenomenon causing massive harm to civilians? Just pick one recommendation based on your, as I said, experience, research, expertise, etc. And that would be precious for us to know how can we tackle this phenomenon. And then I will close the session. So thanks a lot. Mark, you can start if you have an idea, and then we can continue. So thank you.
No, yeah, it'd be hard to kind of pick one thing, to be honest. I started my presentation giving this kind of like overview of how, there's this kind of conflict between what happens, the kind of principles at the international level, and states asserting that they have kind of sovereign right to kind of interpret those controls how they want. But I was very inspired, particularly by Florence's presentation. I think at one point she said, you have to keep working at multiple different levels at the same time. And I think maybe this point that I made about the kind of international and the national level is not actually doesn't necessarily have to be a kind of a barrier, that these things are kind of coexist and kind of conflict with each other, and actually just creates multiple points of entry. I was very inspired by the different presentations in terms of seeing that there are just many different things that can happen, things to do with kind of corporate social responsibility, court cases, parliaments, the NGO work. It's not a very kind of concise and helpful comment, but I would just say all of these things simultaneously need to keep happening, because they're all kind of points of entry and points of pressure, and that I would find it hard to kind of pick out one. And that maybe this point that I made, that there's this tension between these different principles in international law, is actually more of an opportunity, because it creates multiple points of entry for action and pressure to be exerted. Thank you. Thanks so much for the great presentations and the event.
Thanks a lot, Mark. And what you said is actually really, really important. So trying to find convergences rather than divergences, and try to foster conversation at more levels. So this is a key aspect, I would say. Then Florence, over to you. Pick just one recommendation. It's really difficult, I know, but we can try to do it.
I think really following the governance gap, I think we have been very, very much behind at the multilateral to catch up on business. and in all areas, not just in the arms, right? We're just constantly behind, and the net worth of what businesses can do financially and the weight that they have politically with that is can't be, you know, we need to reassess how we do that engagement. And so at the UN, more broadly, they have been seen as sort of a a partner in private-public partnerships, or as a cash cow in funding, but they are part of the problem and necessarily need part of the solution as well. And how do we catch that up? And in the arms trade, it's particularly salient, not least because of this licensing system. But we've gone beyond that in other areas like pharma and surveillance in different countries, right? Not globally. So why can't we do this with the arms trade? And I think the answers were partial in what we've said. You know, the commercial interests, the political interests override human rights interests, and that just can't be the case anymore. And our states need to stand up to that. But again, this is sort of a big pink glasses on kind of vision. I think what Mark said obviously applies. Parliaments need to work at it. Martin sort of really nicely laid out the different levels of accountability that need to be worked out. And it's not one institution that's going to do that, but networking, that bridging between silos is important.
Yes, this is a very important point as well. So involving the industry, involving all the different actors. And I think, yeah, it's essential to tackle the problem and carry on with the negotiations, with the discussions, listening to every voice, every possible voice, and every possible actor playing a role in the arms trade. Okay, Nourhan, it's your turn right now. Just pick one.
You cover all the things that. Thank you, Martin, and that Mark, and also Florence for the stressful about this responsibility for cooperation. I feel that's the big main takeaway. I will take it when I finish this event, and I think it's time for thinking also about the regional organization. Maybe we should to think also about the informal meeting, usually open meetings with the state and government, try to influence them, to engage with them and highlight them some topic. I feel that we can, as a civil society, also trying during the meeting of ATT, make a special informal meeting, because I feel they give to them like safe space to discuss. When you tell them this is informal, this is just discussion, this is but try to building a trust with you that can think about this. And I'm also, I will stress about thing that also young people and the movement of the young people in this armament issue, that's important to involve, important to listen to them. I'm happy because also I'm one of those. I just try to share my idea. Usually I try to highlight the different views. Maybe I'm right, maybe I'm wrong, but I'm learning. And just this time for the young people to participation, and especially in area of armed conflict, because they know and understand about the issue. That's all.
Thank you very much, Nourhan. Yeah, I do agree. Involvement of like so many different actors, as we already mentioned, but also involvement of the young people in the field is essential to, to, let's say, have successful and meaningful conversations. So we need to include more young people, more students, and that's also what we are trying to do with our webinar series. So that's fantastic. And then Martin, it's your turn. It's very difficult just to pick one aspect, I know, but I'm sure you can do it. Over to you.
I think I would say, in relation to the UK, but to other countries as well, stop treating international humanitarian law and international human rights law as obstacles to be got around in trying to sell weapons. Treat them instead as a filter through which bad arms sales can be weeded out. And yeah, that's it. That's if it's one thing, it's that.
Short,
and
yes. Sorry.
you know, the others have said these things much more eloquently, and it's been a good panel to listen to.
Thanks a lot. You were short and efficient. You made your point and it's very clear, so there is no need to explain it further. Okay, so now it's the time to wrap up because time is running fast. So this concludes our Q&A and brings us to the end of the webinar. So really thank you once more for your time, because we know that you're all super busy and that disarmament agenda is full at this specific moment. So many thanks. And also for your thought-provoking insights and presentations. They are really precious, and I really hope that they will reach as many people as we can. So we'll share share the recording of our session in order for people to catch up if they haven't attended. And then we will also ask you, perhaps, if you're interested, to join our newsletter. You can either write at our email and follow Scrap on social media. That would be also very, very nice. And share this session and the other session as well on social media. So I thank you once more for your participation, and I wish you all the best with your careers and with all the other meetings and so on you're engaged with, and the research projects as well. So thank you very much. I really hope to see you again, either in Geneva or somewhere else, who knows, in one way or another. So yeah, many thanks again on behalf of the whole Scrap team. So thanks a lot.
Thank you. Have a nice day, everyone.
Bye.
Or nice
Bye,
night,
everyone.
Mark.
Yes,
Bye.
or night.
Thank you.
See you.
Bye.
Thanks.
Bye. Thank you.